So I am a collaborative family lawyer and accredited family mediator, and I spend all of my time practicing in either collaborative practice or mediation. So I have an entirely settlement-based practice, and I'd like to talk to you today about collaborative practice. So first of all, collaborative practice is a structured, closed, principled negotiation process. So what do I mean by that? We're going to kind of break that down a little bit. What does principled negotiation mean? That means that it's an interest-based process where we care about the law and we also care about what truly matters to our clients. So we call those interests, diving down beneath the positions, so beneath the I want the house, and beneath that into what is the interest underlying that I want the house. It might be things like I want stability for the children, I want continuity in terms of their school, and so I need to stay in this school district. It could be that I have a nanny suite downstairs and our nanny lives there, and so I can't imagine moving. So we start to get at some of the whys beneath the what. And by doing that, we apply the sort of model of interest-based or principled negotiation. So in principled negotiation, it is the attempt to achieve that win-win. So we have the classic example of the orange, and two people want the orange, and you're either one person wins and gets the orange or the other person loses, or you compromise and cut the orange in half in interest-based negotiation or win-win approach. You might find out why people want the orange, and one person might want the orange because they're hungry and they're thirsty and the orange is the perfect fruit, and the other person might want the orange because they're baking muffins and they need the orange rind, and so that win-win emerges from the exploration of the why. So collaborative practice explores those whys and get at what's truly going on to resolve as many issues as possible in that kind of interest-based approach. And then we might move to other styles of negotiation like insight, or we might move into a compromise for some of the issues, so that by the time you get through maybe 80% of the issues, you've done it in a way that is interest-based, and then you've got 20% of the issues left where you might have to do compromise or some of those win-loses where one client is giving something up. So that is the principled aspect of collaborative practice. The closed aspect is that it is a process in which the negotiations are closed, so that what stays in Vegas, what happens in Vegas stays in Vegas. So what happens in collaborative process stays in collaborative process. One of the things that is maybe most well known about collaborative practice is the disqualification clause. So to come into a collaborative practice, the clients sign what's called a participation agreement. And in that participation agreement, there's a disqualification clause. And that disqualification clause says that if the issues aren't settled in the collaborative process and the clients need to go into an adversarial process, such as litigation or such as arbitration, then they need to get new lawyers. So as a collaborative lawyer in a collaborative practice, I am not able to then represent that client in an adversarial process, and neither is their spouse's lawyer. So that disqualification clause has its pros and cons. So the benefits of it are that the clients are really showing a commitment to settle. They're investing in settling. They're investing in a process where they're going to roll up their sleeves and try hard to settle things out of court. And the lawyers are also making that investment. And the lawyers are committed to helping clients in this process. And all of a sudden, all of my skills, everything I hear from clients, I don't sort of have one foot in the door of the settlement room and one foot in the door of court. I'm firmly planted in the settlement room where everything I hear, I can hear with settlement ears. So how can I use that to settle, not how can I use that against somebody in court? So it really allows the lawyers to be fully focused on settlement every step of the way. It also helps because everybody is focused on settlement. It tends to, one, increase the likelihood of settlement, and two, decrease the level of conflict, which ultimately is one of the biggest factors as to how children fare post separation and divorce. So one of the other things that we want to think about with this disqualification clause is what are some of the risks or worries about it. So one of the risks would be that clients get attached to their lawyer, they invest a lot of money in time in the lawyer getting up to speed on what matters to them and who they are and the facts of their file. And then just when things are hitting impasse, they have to start all over with a new lawyer. So that's the risk of the disqualification clause. Also, we want to make sure that clients and lawyers are aligned in purpose. So if my client really should be leaving collaborative process, it's really important from a collaborative lawyer's perspective to keep that ethical approach to this has got to be what's good for the client, not what's good for me. And them leaving this process is what's good for them. I need to support that. And so one of the things that most collaborative lawyers do is we offer our clients a facilitated transition to a litigation lawyer if it becomes necessary. So I let clients know that I would go and help them find a litigation lawyer, that I would go to that first consultation with the litigation lawyer and help that lawyer get up to speed efficiently. And I don't charge for that hour where they have two lawyers at once. So another part of the participation agreement is some protections around prejudice and limitation periods. So there's usually a clause in there that says that the period of time in settlement won't be used against somebody for failing to proceed in advance with a support claim. There's usually also something in a participation agreement around potentially a tolling agreement around limitation periods, or potentially the ability to commence litigation solely for the purposes of preserving a limitation period and then immediately proceeding with the collaborative process. So another thing about the collaborative process, we talk about it being principled, we've talked about it being closed, and now sort of talking about it being structured. So there are sort of a series of guidelines or protocols that we follow, which have kind of been tried and true in helping clients get from beginning to a fully executed separation agreement. And we start with, as we do on most of our family files, with full financial disclosure. So part of the collaborative process requires voluntary financial disclosure, and that's the first thing that we get started. But we do it a little bit differently than in a traditional negotiation file. So for example, in a traditional negotiation file, we usually start with the immediate exchange of sworn financial statements. Whereas in collaborative practice, we usually start with a gathering of all of the data, all of the hard copies of everything's tax returns, valuations of houses, valuations of businesses, we'll talk about in a minute, the supporting documentation for investments and debts and all that kind of stuff. And we take a look at that, and we often start with exploring that from a net family property statement, for example. Whether we have sworn financial statements come a little bit later in the process is partly because they require some level of positioning. You've got to put your best legal foot forward because a sworn financial statement survives the process, so that what happens in Vegas stays in Vegas. Sworn financial statements are something that do survive the process and don't stay within collaborative. And so it becomes an opportunity for a more positional, more aggressive stance. And we first want to get all the information before people start feeling the need to set themselves up for a litigation success. We really want to set them up for settlement success. So we really look at all the financial information, and then we explore whether the sworn financial statements or whether they'll be swearing the net family property statement. One of the other things that collaborative process requires is some level of good faith. So it really does require some level of good faith to try to negotiate, to not abuse the process, to not use it to create delay, to not use it to create advantage. And so that is one of the expectations. And within collaborative practice, most of the work, the negotiations, are done in settlement meetings. So what does a settlement meeting look like? It looks like, at the very minimum, it looks like the two collaboratively trained lawyers and the two clients, and it would be a four-way meeting, but with more structure than we might think of it in the traditional lawyer-assisted negotiation. So there's always an agenda ahead of these meetings. There's always some prep of a client with the agenda. If you're going to talk about your goals and concerns, we're first going to prep so that you can say that in a way that it'll be palatable and able to be heard by your spouse. There might be an opportunity for also prepping as to how you're going to hear and make sure that your spouse feels listened to. So there's some coaching that happens. There's a shared agenda that the two lawyers agree on and that get buy-in from the clients. And then after the settlement meeting, there are progress notes that are approved by both lawyers before they go out to the clients. And those progress notes are sort of general high-level minutes of what happened at the meeting. And they help keep track of the progression and the homework. One of the things that sort of sets collaborative process apart and I think makes it uniquely well suited to helping clients settle their issues out of court is that it has the capacity and is often an interdisciplinary process. So by that, I mean, we work together in interdisciplinary teams on most of our files. So we have the two collaboratively trained lawyers working with the two clients, and we also have the option of one or two jointly retained neutrals. And so, for example, we might have a jointly retained family professional who's usually got a social worker background or a psychology background, and they would potentially be doing some of the parenting mediation and creating the parenting plans that would be attached as a schedule to the separation agreement. And they also would support and coach the lawyers in working with their clients, and they might be part of the meeting to facilitate some of the hotter button issues like spousal support, duration, those kinds of things, where really when we know there's going to be hotter buttons, that though they are there to help manage some of the emotional content in the room. And the other possible neutral person is a neutral financial person. So they might be a certified financial planner, and they are potentially the person who's gathering all of that financial information that we collect and potentially drafting that first net family property statement, maybe supporting the lawyers and running various support calculations, sometimes running projections for clients on different models. If they're trying to decide between a lump sum spousal support or a monthly spousal support, they might run some projections to see how that looks like over time. And sometimes we have all four of us, two lawyers and a financial neutral and a family professional neutral. Sometimes we need a jointly retained business valuator or income valuator if there's a business or income that needs valuing, or notional disposition costs that need valuing. And those people are usually jointly retained as well. And we really need to decide whether those are with or without prejudice. So are they going to be a report that stays in process, and if they leave process without a settlement, they've got to go redo that and hire somebody new? Or for most of our clients, they choose it to survive process. So they will choose a with prejudice report that actually survives process and can be used if in fact they don't reach settlement in this process. I sort of think of collaborative as a bit of a hybrid between mediation and lawyer-assisted negotiation. Sort of, to me, it combines the best of both worlds and provides this opportunity for an interdisciplinary team. One of the other things in terms of, we talked about it being a structured process, so there's the financial disclosure part of the process. There's the settlement meeting focus where things are done at the table rather than in a lot of back and forth between the lawyers. There's the progress notes that get distributed to the clients after both lawyers have approved them. We don't tend to write letters. There's not a lot of letters going back and forth between the lawyers. We pick up the phone, talk to each other, try to sort things out without letters, which can often be inflammatory for clients. So more phone calls, quick emails, not so many letters. When it comes time to actually drafting the separation agreement, we will, both lawyers have to approve the draft before it goes to the client. So rather than me and my client working hard on a draft agreement, loving it, making it perfect, and then sending it over to the other lawyer for them to edit it to heck with their client, we have both lawyers have to commit and agree that this recognizes what the clients have agreed to in spirit and intent and in detail. And only once both lawyers are okay with it does it then go out to the clients for their review, and each of them would review it with their own lawyer. We often have signing meetings at the end where we come together, and rather than just my client signing it at my office and the other client signing it at the other lawyer's office, we often will have a signing meeting where people will come together and sort of sign it and close off the process and that kind of phase of their separation and their marriage in some sort of meaningful way. Not all files settle that way. At some point, some don't feel comfortable by the end being in the same room and just want to go and sign it at their own lawyer's office, and that's totally fine. One of the things that I wanted to just sort of go over before I finished off was this idea of success. So first of all, 90 to 95% of collaborative files settle all issues within collaborative. And that's both an international statistic and also a local statistic. For those that don't settle all issues in process, they usually have all of their financial disclosure done, potentially a partial agreement on property and maybe a temporary agreement on child support, and then it might need to leave process to have the spousal support issues resolved or the longer term child support issues resolved. And one of the things that we sort of think about in terms of collaborative is redefining success a little bit. So success isn't necessarily, oh, my client did better than they could have done at court. Success is really defined by clients at the beginning when we're checking in with them of what success would look like. And for most clients, that means, sort of a reasonable outcome where I'm okay. It means a process that didn't take too long. It means a process where I didn't spend more money than I think was reasonable. I didn't have to take so much time off work to come to 1,000 court dates or 1,000 meetings. It means that I have a decent relationship with my spouse, and we're able to, if we have young children, we're able to parent our children together. If we have adult children, we're able to show up to births of grandchildren and graduations and weddings and all those things together without causing our children stress. So I've achieved a reasonable financial outcome, and I also have a decent relationship with my spouse. So we really do work in this process to try to help clients sort of have difficult conversations, negotiate potentially challenging issues in a way that leaves their relationship intact. And in most of our cases, we're able to do that.